All right, I have 3 files here. I have so 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373ON. People in the city of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And turn it over.
Good afternoon, Your Honor. This is the time set for pre-trial possible motion hearing. I received no motions. I don't anticipate there being any at this time. And we just asking if we continue to the jury trial date, as my associate has indicated that Mr. Gonzalez is not ready and is not inclined to accept any so far.
All right, thank you for that. And then Ms. Renfro, you can go ahead and state your name for the record.
My name is Christopher Allen Renfro. Today I am demanding vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminal, so I might was vacated also. No, there was no proof nor burden that the testimony of the cop was true, and also no evidence. I still have not gotten discovery, which means it doesn't sound like plaintiff is ready to move forward either. So that's my statement. I demand that court vacate these matters and restore them whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismissed, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro makes that he does not have?
There's a police report of the criminal matter and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously and did not take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff, and that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, I would go, don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm going to make sure it happens. So if you want discovery, how do you want it in it?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. So if you don't want discovery, that's fine. In regards to work, also I want to mention, not right, but somewhat maybe along the path towards that somewhere, when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason, because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to that?
I have none, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended or commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. And again, incorrect. Also, Declaration of Independence is a law. Declaration of Independence was a declaration that we made to the King of England about what we wanted to see happen in this country. So that's not law. I wouldn't hold that anymore. I would hold
Reasons why
other
I went to
things.
war with England.
One more time.
I'm an American.
Don't interrupt each other. We're going to keep doing this, and I'm going to keep reminding you of that, because if you try to do it while we're having a jury trial, I'm going to shut it down way faster, because we're not going to do it in front of a jury. All right? So, again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that would be more convenient for everyone involved, and we do try to be convenient for people rather. Okay, and so let's set this then for.
I believe it's already set. I believe we're going to go by
Sure. But it was not set. If we set this for August 7th, Mr. Renfro, is that an acceptable? I know no date is acceptable to you, but are you free on August 7th?
Promise, I'll be here.
Okay. All right, you'll get a notice. We won't send any summons, but we will send a notice for you.
Only someone's the son of that.
Well, if you don't show up, I'm going to issue a score for your arrest. So be fair and warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first, so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we have to bring jury back. Last thing before we leave, Attorney O'Donnell, you mentioned that, actually, there's two more things I want to talk about before they. One, you mentioned that today was.
Let's practice our pronunciation. Repeat after me, speaking slowly and clearly. El clima de hoy is absolutely hermoso. And here's the reality check. The judge clearly explains the risk of self-representation. This is one of the most important moments in the entire hearing. Representing yourself might sound empowering, but legally it can put you at a serious disadvantage. The defendant seems confident, but confidence doesn't replace legal training. So what do you think? Should courts push harder to appoint attorneys in situations like this, or respect the defendant's choice no matter what?
Excellent! You got the intonation exactly right. Next sentence. Me gustaría pedir un café grande, por favor. Me gustaría pedir un café grande, por favor. Perfect! Your phrasing is improving so quickly. Keep up the good work.
For pre-trial and motion, and I do have as well have it. There was no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay. All right. So I don't know why that was set for that. I know you made an oral today. I'm confused. All right. Well, then that's not an issue. I will also note that right now the jury trial actually has a date for Friday, September 5th.
Yes, that was the day that was
This is the date for Mr. Downey. Okay.
And we are virtually instead of doing it going side.
Gotcha.
And we just have to only walk.
Gotcha. All right. So you want to do August 7th or September 5th? Let's say either day. So that'll be fine.
Well, and of course, especially now.
I'd say August 7th is good days and so we're gonna we had it originally set for
That's
July 25th. We had to move it if there was some kind of notice here. Maybe I don't remember what happened that day, but it was something weird. So then we moved it, but we'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we already talked about this, but it is your intention to represent yourself in this matter. Is that true?
My intention to resolve this cause.
Okay, you do not want me, to ask for the defender's office to appoint you an attorney, is that right? You don't want that, right?
No.
And you do not want to retain an attorney, is that right?
Right, I'm confident. I will see if it matters to myself.
All right, you understand, I know we've talked about this before, but you understand that attorney of that, the people that work in our office, that are lawyers, have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are gonna place yourself at a significant advantage by representing yourself. Do you understand that?
Advantage? Yeah.
At a disadvantage. I'm sorry, I didn't say advantage, at disadvantage.
I see it another way, but that's.
And that's fine, that's why people represent themselves, and they think that they can do it, and you seem pretty confident to me. As long as we all respect each other and respect this room, everything will be fine, and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have a problem. Okay? All right, I think that's it for today. Thank you.
May I have a 5 seconds for Mr. Randolph? Yes.
Yes.